Okay, since we're already a bit behind schedule, if people could take their seats. If people could take their seats, please. Well, that was a great panel. A little bit of a hard act to follow, but we will try. The title of this panel is Antitrust: the Next 4 Years. As Yogi Berra said, it's difficult to make predictions about the future, or especially about the future. But we have a great panel assembled here today that is going to make a valiant effort to try. Bob Crandall is an adjunct senior fellow at TPI and was a long-time senior fellow at the Brookings Institution. Ginger Jin is a professor of economics at the University of Maryland and served as director of the FTC's Bureau of Economics from January 2016 to July 2017. You've already met Bill Kovacic, and Michael Katz, who has made a yeoman's effort to get here today since he was kind of under the weather, so I really appreciate that. He is a professor, but Michael at 90% is better than most of us at 100%. Michael is a professor emeritus at the Haas School of Business and the Department of Economics at UC Berkeley. He's a former Deputy Assistant Attorney General for Economics at the Antitrust Division, as well as a former Chief Economist at the FTC. So let me start by providing a little context. The current antitrust team at the FTC and the Department of Justice came into office saying that the previous 4 years of antitrust enforcement had been a failure. They targeted big tech explicitly and criticized the consumer welfare standard, which had previously been the basic standard for antitrust enforcement, and they adopted a much more aggressive merger enforcement policy, among other things. But Republicans have also been harshly critical of big tech, some Republicans. The Republican vice presidential nominee, J.D. Vance, has praised the policies of FTC Chair Lina Khan and called for breaking up big tech companies. And there's even a new name, conservatives, for conservatives who support that point of view. So my first question is, kind of two related questions, does this increasing populist sentiment on both the left and the right, including a distrust of big tech, mean there's a convergence of views on antitrust enforcement? And kind of related to that, is big tech the type of problem that should be singled out? Should the big tech companies be targeted? So let me just start by going down. Start with Bob and just go down.
Well, much of the criticism of the big tech platforms addresses issues outside of the realm of antitrust. And as many people have observed in the past, they deal with misinformation, all kinds of political issues that are not easily addressed by antitrust. But the second thing is, it's not clear how antitrust can be successful in addressing the market power of the large platforms, where there are any remedies that are available. For instance, I guess we'll probably talk about the Google decision, which can reduce their power given the platform economies which govern their operations. So I'm skeptical that antitrust is a solution, and I think a lot of other people are as well, and that's why they're looking for regulatory solutions, which we can also talk about later.
Ginger?
Yes, thanks so much for having me. I guess my answer is we're far from a consensus, not just the political type of view, but also even in the economic perspective. I think there's three questions that probably subject to a long time debate. One is, how should we think about big versus small? It's not just big tech. I think they exactly whether big is bad versus big is efficient, and how big firm and small firm interact with each other in the innovation space. I think that's a very important question to address. The second, I want to add on Bob's point of other things outside of antitrust. We have seen a lot of consumer behavioral bias, including the default bias in the Google search case. I sort of disagree that we should view those non-antitrust things completely out of antitrust. We see more and more interaction and blurry boundary between those kind of behavioral bias and antitrust. I think the second question we need to address is how should we think about consumer behavioral bias in antitrust enforcement? And the third one, as you mentioned, I think the consumer welfare standard is still very much subject to debate. Exactly what do we mean by consumers? What if some consumers get harmed by this practice but others don't? What if one side of the business got harmed by this practice but the other side benefits from it? And how to trade off between all of those, I think that's the question that have to be addressed in the welfare standard.
So, and Bill, maybe you could address the question, but also talk a little bit about kind of this influence, this kind of populist influence in antitrust these days, as well as obviously other things, but we're here to talk about antitrust.
Yeah, I think there is certainly a great deal of spoken concern on both sides of the political spectrum, but it's not clear that they have a common view about precisely what the problem is or what to do about it. I think Senator Schumer found at the end of 2020 is there was a great deal of support for giving time on the legislative calendar to consider legislation. I think his view was there are a lot of people who want to do something left and right, but I can't write a bill that says the act of something. I need a specified menu of specific interventions, and there is no agreement about that, and I'm not going to give you precious real estate on the Senate calendar to talk about something. And I think that remains a concern. That is, where do they agree to do something? That's why we don't have a Digital Markets Act. It's why we don't have a Digital Services Act. It's why we don't have a national act dealing with AI yet, or even a National Data Protection Act. So lots of anxiety. And maybe it's the anxiety focused on AI in particular, that it's a bit like the Sorcerer's Apprentice, that it runs out of control and it defies effective human oversight. Maybe that's a shared concern, but not coalesced around a specific set of proposals. And indeed, as you mentioned, we've seen the emergence of a remarkable new literature and coalition that begins building in the early 2000s. It's reinforced by the global financial crisis. 8 million people lose their jobs, 6 million people lose their homes, a basic social concern about whether the economy works effectively, whether regulators work effectively. That is transmitted into powerful political movements. Bernie Sanders and Donald Trump had a lot in common in 2016, appealing to the same audience, the same concerns. And then through the election in 2020, Joe Biden makes a fateful promise to Elizabeth Warren and says, you'll be the gatekeeper on key economic regulatory appointments. He fulfilled that. I mean, that stratum of underlying concern, broad-based in society, I think had a major role in propelling this new literature to the fore. A literature, as you say, Tom, depicted the period before 2020 as a period of calamitous policy failure.
Michael?
I was doing fine until you got to asking me the question. Look, I think it's pretty clear there is no consensus. J.D. Vance said that Amazon funded Black Lives Matter to destroy competing retailers. I'm pretty sure that's not a Democratic Party position. No, I think there's a huge difference. I mean, look, consistently, actually, I shouldn't say consistently, across the board, there's certainly a strain of people on the right who their concern with big tech is really about what they claim is censorship, and that they're not allowed to have their message on, and that the claim that big tech is colluding with the Democratic administration. Again, there's not a consensus on that with the Democrats. Now, there is also a strain of Republicans now who are in favor of sort of more traditional, you might think of more traditional antitrust, against big tech, and they do have concerns. And Vance is actually even in that category as well. I mean, he introduced a bill that wanted to change the tax treatment of certain large mergers, and that was going to be across the board. So, I mean, I think we are seeing a change, and at some level there's convergence and they want action, but the reasons for wanting action, I think, are just wildly different. I don't see that this is going to lead to legislation. As to whether we should have it, I guess I'd say a few things. As Bob said, a bunch of the problems with big tech, and I agree there are problems with big tech, and I should also say I've worked for and against them, and so I should disclose that. But, you know, a lot of things like privacy, concerns about whether they're promoting misinformation, disinformation, it's not at all clear. In fact, I think there's a lot of reason to believe that increased competition would make that problem worse. And so antitrust is not going to be a solution, and I think we do need some form of regulation. But then it raises a question, okay, and we're going to need legislation to get there, and we'll see whether the Supreme Court allows it. But there's also the question of, well, do we need legislation for antitrust? And do we need to do something? And then I think you have to ask yourself why. And I don't think there's anything wrong with the Sherman Act or how you can think it's outdated given how incredibly vague it is. I mean, it can cover anything. And so if people are saying that, I think if you think there's a need for legislation on antitrust, what you're really saying is you don't like the way the common law has evolved and what the Supreme Court's doing, and that you want a legislative reset to, you know, again, to undo what the Supreme Court has done. Again, I don't see there being any consensus in Congress to do that. And the other thing that concerns, and I think there is some reason to want to have that sort of reset, but it does concern me a lot that I think some people want to move to regulation because they say, look, it's just too hard to bring an antitrust case. We always lose. It's too hard to prove things. So let's just have something where we get to just impose the answer. But you should ask yourself why it's too hard to lose. And if it's because you think the courts have, you know, put in a set of rules or the common law has gotten sort of out of control, that's one reason. But if you think, well, these things are really hard to know which way it goes, and so we shouldn't have to prove it, let's just decree the answer, I think that's the wrong reason to regulate.
Okay. Again, on this question of targeting big tech, the FTC, as we all know, the FTC and the DOJ have major cases underway against all the big tech platforms, and the case against Google Search was decided a few weeks ago in what is considered to be a major victory for the government. Although obviously there's lots more to go before we know what the final resolution will be. The Google opinion found that Google had acted illegally to maintain its monopoly in general search, and the opinion focused on Google's agreements with Apple, Samsung, and other distribution channels to be the exclusive pre-installed search engine. Well, let me first ask whether you think, and this is also something that Commissioner Holyoke was talking about in the previous panel, do you think the opinion gives sufficient weight to the interests of consumers? I mean, what if anything does the opinion say about the status of the consumer welfare standard? Anybody want to take that to start with?
I would say the judge does not anchor the decision in that framework. I think there's a view that maybe the vocabulary doesn't work well in these settings, that there has to be a redefinition, because to say consumer welfare in many events provokes a fist fight before you go through a definition of what you mean. So I think in many ways a key premise of his decision is that the concern perhaps is certainly for consumers, but it's forward-looking. But for the restrictions that he spoke about, you'd have a more vibrant, innovative environment in which you'd have new products, new services that would be attractive. So I think ultimately he is concerned beneath his discussion with consumer interests. But the premise of the decision is that if you ask how are they ill-served here, they're ill-served by forestalling the emergence of other possibilities that would serve them well. So it takes into account the innovation, dynamic market effect. I think it is consumer-oriented, but that's That is the orientation, that there is something better on the horizon were it not for these controls.
And House, I mean, obviously, a lot of people have said this is an extremely significant. Obviously, it's the first case, the first big monopolization case after the Microsoft case. So obviously, for that reason alone, it's a significant case. But people are saying it's a very significant case. What will be the implications outside of, for Google itself of this case? But Ginger, you.
Yeah, I just want to add to that. I feel like the judge's decision is implicit about future innovations, but does not give a clarity on what the counterfactual world would be. If you look at the economic literature, both theoretical and empirical, the number of firms does not necessarily increase monotonically with R&D investment or innovation outcome. And it's also not necessarily true that big firms always invent worse or slower than small firms. Actually, if you look at the ecosystem, there are very complicated interaction between big firms and the small firms. Big firms sometimes fund small firms for their innovations, and sometimes the prospect of being acquired by some future big firms would motivate a small firm to innovate more. And in the case, we see a lot of big firms competing with each other in innovation, not just in the traditional technology of search engine, but also in, say, ChatGPT type of future search engine models. I think the counterfactual of innovation world is very complicated, was not explicitly considered at all in the judge decision, but it sort of implied that, okay, if we remove this contract, the future world of innovation would be better. I wish it has been more explicit and probably coupled with some quantitative analysis on what that will be.
Well, I guess what I was getting at a little bit is, did you have something to say, Michael, or did you? Is that it seems to me that one of the basic ideas, in the opinion, is that if we make life a little bit more difficult for consumers by not giving them the default that we think they prefer, then that will produce more competition, which will produce these good results in the long run. Maybe that's the way I'm reading it.
Yeah.
So in that way, yeah. So, Michael?
I have to admit, I have not read every page of the decision, and I also have to admit, even in my head, I wouldn't remember it. But looking through the decision, I can't figure out actually what the judge has said is the illegal conduct. In particular, an issue, I'm told, I wasn't there, at trial is whether or not you have to have a but-for world. And it seems to me whether or not you think of it as a legal requirement, it's a logical requirement. You can't say what the conduct is unless you can say what it would mean for the world to exist without the conduct, right? Because you say, okay. Now, the judge cited the Microsoft standard, which I'll do my amateur lawyering. I interpret it more to say, look, it's difficult to predict the future, and you can't require the plaintiff to say, oh, here's exactly what would happen, or maybe even here's what would happen with any specificity. But it still seems to me you need to say what it is you think should have been done differently, and then you can say, and here's why it would matter. But what the judge seems to be saying is, well, these contracts that they had denied Bing and others scale, and there's certain features of those contracts you could see going after under sort of traditional antitrust, and the extent to which Google demanded that they be exclusive and that they wouldn't allow them to be broken up. But other parts of the decision, you read it, it's just like, well, the fact is they paid for the default is bad. But then he never really says it's bad. And so I think it's going to be an interesting issue when we get to remedy, given they haven't really defined what it is that Google should have done differently. You could have imagined a different case where they said, Apple, you and Google are both your co-conspirators. Maybe we're going to bring the case against Apple. You shouldn't be allowed to sell the default. But they didn't bring that case. They seem to say it's fine to sell the defaults, so was Google not supposed to bid on them? So that's my concern with the case is it just wasn't clear enough about what they're really doing and what they think is the precise conduct. And so that's where I think it's could maybe fall down in terms of protecting consumers. It's not that the judge didn't think he was trying to protect consumers. Right. It's just I think he had the wrong framework.
I think you put your finger on the element that he would have said were Judge Mehta here on the panel, he would have said, yes, you've captured it more precisely. It's the demand for exclusivity. But that's not, that theme is not perhaps emphasized enough throughout the opinion. There are points at which he says, well, you bid so much for the precious spot on the iPhone, and you wonder if you look at that in isolation, are you saying you shouldn't have bid? You should have bid less, shouldn't have been so aggressive. What is, as you put it, the counterfactual? I think it's the sometimes not emphasized theme of exclusivity, which is what he would say that's the bad act.
So both Michael's comment and Slido suggest that we move on to the question of remedy in the Google case. So, I mean, what do you think? There are obviously a bunch of remedies that have been proposed, from divesting Chrome and Android to just saying you can't do what you were doing with these particular contracts, and the Apple type contract, or providing a menu of choices, or so a variety of providing access to AI technologies and data. Some people have suggested. So, what I'm curious as to the panel's view on what they think DOJ will propose, whether or not, and what they think a good remedy would be.
Yeah. Well, first of all, it's absolutely clear that after a 268-page opinion, that the judge focuses only and solely on the exclusive distribution agreements. And as if they are either too long, or the people supplying the exclusive distribution agreements, Samsung, iPhone, don't see an advantage in this exclusivity. But even if you don't get exclusivity, as they don't get on the Windows platform, Google gets 80% of the search on Windows. You can go in immediately and change the default from Bing to Google search, and that's what most people do. So it's not clear how what remedy you could propose. Divesting them of Chrome and Android would seem not to help, given that they don't own the operating system or the browser on the iPhone, and yet they get huge share, 90% to 95% share of that. To require, I'm not sure they can require that Samsung and Apple not offer exclusivity, because they're not litigants in this process. So I don't know what the solution could be.
I think the remedy will depend on how we view the consumer behavioral bias, in this case, the preference for default, right? If we think that's, okay, that's what consumers want, we should respect that preference, and then maybe the remedy is, okay, we allow the default contract, it just somehow prohibit the exclusive part of it. Or it could be that we think consumers don't know what they're doing, we should give them choice, or even force them to choose, even if some of them will prefer to have a default without a choice. And if that's the philosophy, then maybe the remedy would be a choice screen, as what EU has been
But
doing.
how do you force Apple and Samsung to not offer an exclusive default? They're not litigants in this process. You can't force them to do that.
Well, one issue, though, and again, I don't know the facts, so supposedly there were times when Google did want the scope to be broader than the other companies wanted, and that Google wanted to be exclusive in a way that Apple didn't. And so there is a place where you, but it be behavioral, you could say to Google, you can't demand these things in negotiation, although that seems somewhat limited relative to what I would guess are the DOJ's ambitions.
Yeah, just one thought on the consumer welfare first. In the Microsoft case, the harm to consumers was all future-oriented. The court says, what was the harm to them right now in terms of price, quality? None. It's future-oriented, so it was the longer-term effect, but it was within a consumer framework. I'd say here there'd be three options for the department to pursue. One is, as Mike has just suggested, one is stop it, and Ginger, that is stop it. Don't do that anymore. Don't demand the exclusives. Second would be stop it plus, which includes maybe a choice screen. Maybe it includes access to data, access to information. The third is structural relief. My intuition is that the DOJ indeed will offer the second and the third, at a minimum say, we want to prohibit the demand for exclusivity, but we want more than that. We want something that's more restorative, which means either stop it plus other concessions related to the choice of alternatives that consumers have. And the last would be some form of structural remedy. Why do I think they'll give this? And I'm absorbing in part conversations I've had with several of you who followed this. A view I agree with. Judge Mehta, I think, is very thoughtful, but he also sees himself as positioning his work in a mainstream that's very careful. And a way to frame, notice in the opinion, he framed his decision in a careful way. He didn't give the government plaintiffs everything they wanted. He cast the state claims aside. He didn't give the government the finding on monopoly power and dominance that they wanted in a larger span of markets. It was more limited, more measured. So that's one way of saying, see, I was measured, I was careful. A way to do that on remedy is to have the larger menu in front of him and to say, I'm not going to pick the divestiture. I'm going to pick stop it plus something else. That's the one I'm going to choose. That makes it more impervious to effective challenge. I think DOJ offers the structural option as a way to provide the frame in which he can say, I'm going to pick the one in between.
Yeah, actually, I think I agree with everything you said. And it actually, I guess listening to you.
By the way, I haven't spoken to Judge Mehta about this, so I don't.
Lead me to predict that something like the mandatory data sharing, you could easily see as an outcome. But right, judges are people, and the thought that you would spin off Chrome or potentially Android, and who knows what would happen to them, that's a pretty big decision to ask a judge to make. Data sharing seems a lot safer because the public generally won't see what's really happening. And you do have this rationale that what you're doing is you're trying to restore the competitive conditions that the conduct's allegedly destroyed. So.
I think one thing, we mentioned the European framework with DMA yesterday. One thing I suspect DOJ will be thinking of is, I'm going to look at everything Google has basically said it will do already in Europe. And if you've shown the feasibility of that, including data sharing, we want that as well here. You've shown you can do it. And I suppose the other thing they have one eye on is what remedy are they going to seek in the ad-serving case in Virginia? That is, same defendant. If you look at both of them together, what is your larger remedial plan? I don't know what that broader vision is, but I would think that would have to affect what they asked for in this case, too.
So speaking of the DMA, the DMA really tries to accomplish through kind of ex-ante regulation a lot of what U.S. antitrust enforcers are trying to accomplish by bringing cases. And obviously most of these companies have to comply with the DMA. Is this going to make U.S. antitrust less and less important because it's superseded by a regulatory regime that requires them to do a lot of things that might be in a remedy in an antitrust case?
Not only that, but the DMA is going to be regulating large digital platforms, gateway platforms, none of which reside within the EU. And you wonder what the political economy of that is going to be and whether that leads to any kind of optimal regulation.
Yeah.
Yeah, I feel like the EU has been very hands-on on
very
I guess, 7 gatekeepers they designated under DMA. They're sort of in the ruling against Apple or Meta or the ongoing investigation about Apple's other business is like, okay, they're saying you have to provide this service and free of charge, right? That's like very hands-on sort of, they're kind of running the platform in product design. And I'm kind of very concerned of that kind of utility type of approach. What's the impact of that on innovation? That's the fact that we see those big US firms very successful globally is because they are able to invent a lot in product and services to address consumer demand in a very swift way. But with this really having hands on their product design, right now it's probably restricted to EU, and if the US remedy following that, it could be much broader than that. I'm quite skeptical in that approach.
The DMA is based upon powerful presumptions based on their assessment of their past experience. These are per se rules. There's no flexibility
Right.
for adjustment. I think if we gave truth serum to our European colleagues who are applying those rules now, they would say that we don't have a lot of room there for adaptation. We're learning a lot from what's going on in these US cases. The benefit of having the big monopolization case is that there's a massive amount of information that comes into the public domain that they did not know about. Arguments, justifications they didn't account for. I think the US cases are going to have the indirect effect of moderating, to some extent, what happens in the elaboration of the DMA. But the DMA concepts at the same time, in the way that, that Bob and Ginger were just mentioning, they don't have precise adopters across the world. That is, other jurisdictions have not quite said, I'll take that off the shelf and apply it. But it has been very influential. How much will it cause companies to change their behavior globally is still a bit hard to tell. But the DMA experience does provide, I think, some effort, some support for plaintiffs here to say these are prohibitions that have been imposed. Companies seem to be able to live with them so far, although we don't have a lot of experience with that. And in that respect, it supports the effort of the U.S. agencies to develop the larger factual record that has more flexibility built into it to get remedies that are more nuanced than the ones you'd get in the European experience. So there's a real symbiosis.
So I don't often disagree with Bill, but when he said there's no room for adaptation in the DMA, I have to disagree because they're making it up on the fly, so they're adapting plenty. And I realize you meant something different. But I think that's a real problem, though. The DMA is, it's a lifestyle choice or something. But I think companies, are having a lot of trouble with it. And I guess you could say, to their credit, the Europeans said, well, we know we're doing this and we want to work it out with the companies. But I think it's turning out to be a pretty painful process, and we don't know where it's going to end up. As to what this is doing to the U.S. influence, I think a lot of that depends on whether the DMA ends up having companies do things that they find sufficiently costly to deal with, that they just decide to have different regimes in different parts of the world.
Yeah.
And there's pretty strong pressures against doing that for some of these companies, because they really try to have global strategies, or they may even have globally mobile customers. But I think there is a possibility that is what we'll see. There'll just be fragmentation of the tech policies.
Yeah, Mike, I think they are making it up as they go in a very difficult setting. And I think also that there is more flexibility than I suggested in how you apply the definitions. That is, you decide that this behavior is covered by this prescription, and you have some room there in this negotiation with companies to say, maybe that's not exclusive dealing. So,
and we also have to keep in mind that one of the reasons Europe hasn't done these large digital platforms probably is the regulatory environment there. And not only do they not have large digital platforms, they have much less R&D than we do, given, and they're an equally advanced society with an even larger population.
Do you think, well, to what extent do you think the remedy that is proposed and perhaps adopted will be kind of driven by a desire? Obviously, Google's just one company, but there's obviously this, this concern that the large incumbents will have too much of an advantage in the AI race, and we should do something to maybe take a little bit of that advantage away. Do you think that will be a driving force in the remedy?
I think unmistakably. A theme I've heard from so many senior enforcement officials, both in the U.S. agencies, but also in Europe, is the lament that we failed 10, 15 years ago to forestall the development of firms that had extraordinary power. That was part of the 40 years of failure. That was the grievous failure. The failure to control mergers, the failure of the FTC to at least get a settlement with Google in 2012, 2013, that was a grave policy default. And I have heard them, and I think these are texts that are available in public, a phrase they use is, we're not going to let it happen again. And I think that by that they mean we're not going to let these same enterprises control the evolution and development of this technology. I don't think there's a complete awareness about how to avoid that result. But there's a sense, for example, mergers, joint ventures, you have to dig in and scrutinize each one and resist. That's how it happened before. I think unmistakably, Tom, there's a view that I think it will affect the formulation of remedies because there is this deep belief, correct or incorrect, that policy failed so badly before, and this is another opportunity to redeem that failure by imposing more controls.
I'd like to dissent a bit from that. Tom Hazlett and I published an article in the journal Law Economics a couple of years ago, which showed the large platforms are not that merger intensive compared to other technology firms. I don't think in this case the judge suggested that any mergers that the DOJ could have stopped would have prevented Google from assuming its current position in search. It was superior development of a superior service and these contracts, the alternative of which we can't figure out.
That will be the theme in the Virginia case, yes.
Yeah.
Google DoubleClick.
Well, in the case of Virginia case, at least there is one major acquisition,
Yeah.
and that's DoubleClick.
Yeah.
Well, also, one of the questions in Slack, which I think has disappeared now, but it was that a major aspect of the rationale for the government's case was to help Microsoft. Is that a credible idea? I think.
Well, I don't know about it, but to encourage more development of competitive search engines, but how you do that is the puzzle.
So I think that question, if I remember, was saying, why, I thought it had the flavor, why would you need to help Microsoft? They have so much money already. But I think the answer is, it doesn't matter how much money you have, and ultimately, you're only going to succeed as a competitor if you can be profitable. And while Microsoft apparently was willing to lose a lot of money for a long time to try to succeed, that it's limited how much they're going to do that. And that's, I think, was the basis of the government's case.
But just to play devil's advocate here, and probably because it's very hard for Microsoft to compete in exactly same technology as Google's current search engine, we now have a differentiated approach in ChatGPT and other ways, right? I mean, Microsoft has invested heavily in that, and other big techs are investing heavily in that as well. So it's unclear to me that the counterfactual of, say, Microsoft was helped by the court 5 years ago, and the evaluation outcome would be better than what we have today.
It seems to me a lot of what's going on is that we have the digital industries that have just phenomenally large economies of scale. Some of these things just have huge fixed costs, and think about autonomous vehicles. One, we're just going for decades, losing money to do it. There are also products where they're really important complements, and the complements can also have huge economies of scale and be expensive to develop. So we're going to have this, I think there's a philosophical question is, do you then let firms say, we're going to promote an ecosystem, and that we're going to enter into providing these complements that are expensive and hard to do, but really valuable when you do it? Or do you say, no, you're getting too much control, so we're going to keep you out of those things, even though that may mean then you don't get these very valuable complements? And I think that's something we're going to have to confront, because there are people who basically want to say, you have your innovation in your lane, stay in your lane, don't try to go into a neighboring thing. And even when it's organic growth, and I do want to be clear that I've distinguished that between if you did go in just through merger, or there's these questions now, I guess the FTC is asking about with AI, about what some of these partnerships look like. That seems to me is a different thing. But I think even with organic growth, there are a lot of people nowadays, I'm not one of them, who would say, okay, you guys are too big already, you shouldn't be able to grow into, even organically into this neighboring market. And I think that's going to be a serious problem.
So do you think it's, and even aside from the Google case, obviously the agencies are kind of targeting AI, presumably under the theory that they want to ensure that, that these companies don't have too much of an advantage on the next round of competition. Do you think that's an appropriate policy? There's lots of investigation.
I'm not sure how they create a credible case that they can do that. Since the first antitrust action was brought in late 2020 against the digital platforms, they've grown by 77% in terms of stock market value, while the overall markets increased by 54%. Clearly, the cognoscenti who are trading these securities, these companies, don't think that antitrust is going to have a major impact on reducing their size or scale and operating in the digital economy.
Certainly a question that, again, to go back to one of Mike's points earlier, that hasn't been answered by the advocates of severe restrictions on the platform's participation in AI, either individually or collaboratively, is what would you like them to do otherwise? Do you want them to be spectators? Do you want them not to form collaborative ventures with other enterprises that might have a role to play? I mean, I'm accustomed to hearing the leading participants, that is the large firms, say, at this moment, our interests have the broadest possible participation. That's how we're framing this. We're seeking to have a fairly open environment in which there's large participation by as many as possible, that they're welcoming that as a business model. But alternatively, what are you telling them? To say you can work in isolation, or are you supposed to stand down and allow things to develop perhaps more slowly or by others? It's not clear what the acceptable alternative role is for these firms.
If you think back to Microsoft, would it have made any difference if the approach would have been to ban Microsoft from investing heavily in wireless operating systems, given that they invested heavily and didn't succeed?
No.
I mean, you can't, I don't think you can foresee how AI is going to develop, and in fact, I think Google is more afraid of AI than they are of the federal government in these two cases.
I'll also say, AI, I think, is, though in some ways it's going to come back, same thing as we were saying about privacy or disinformation. If you're concerned about AI, your primary concern is that it may wipe out the human race, then it's not at all clear that you should be promoting competition in AI and try to have the Wild West. And so, and I mean that seriously, because people, they think, oh, you know, somehow small firms are always virtuous, and you know, there's an expression, fly by night. Now, what it would be a small AI firm would still be huge, but having a lot of different firms out there all competing and trying to get an edge, possibly at any cost, actually it raises some real issues. And so I think we need to be thinking about what we think is the right overall industrial and regulatory structure for AI. But the mantra, you know, we need to really promote competition. Not clear to me that should be at the top of the list.
I'm much more interested in what we were talking about yesterday about the possibility of regulatory frameworks that demand more vetting of specific AI applications over time. I mean, I think when you look at other tech experiences where you've had the massive, rapid deployment of new, nascent, and somewhat untested technologies, that's where you get the greatest surprises around the corner. A more substantial process of vetting, I think, would be useful. That's not an antitrust issue.
Thank you. We need to have a level set for this conversation. There is global consensus. There is Republican and Democratic consensus about the problems in antitrust and big tech. There was bipartisan agreement about what to do. At the end of 2020, Chuck Schumer did not say, you didn't come to me with anything to do, so I'm not going to give you time in the legislative calendar. Indeed, we published a report in 2020 that highlighted the abuses that we've seen in the big tech market, a report that has been published in similar terms by other countries around the world, including Australia, South Korea, Japan, the UK, the EU, Brazil, Canada, and the US. These bills that were later developed out of that report were bipartisan. They were supported by Republicans and Democrats. That is consensus. Attorneys general across the country supported these proposals. That's consensus. I also think that it's wrong to mischaracterize disagreement with the common law as something that Congress shouldn't be doing anything about. If we disagree with Congress...
Oh, no, I think it should do it. I think they won't do it. I think they don't do their job. That's not, the constitutional structure is that the courts interpret the statutes, they make common law, and then at any point that Congress wants a reset, Congress should act.
And they did. They introduced bills. They passed them out of committee. They were bipartisan. Okay.
You have a different, you
I
have a
also
different
think that it's,
definition
I
of
also think that
action
it's
than
not
I do.
helpful to be restating misinformation about Amazon and Black Lives Matter at a panel like this. I also don't think it's
Can
helpful.
you tell me what the misinformation is,
It was Michael
please?
Katz saying that Vance said that Amazon
The
had something to do with Black
Christian
Lives Matter.
Science Monitor reported that he said it, I think, in 2020 to a group. And
That doesn't make it any less misinformation.
Let's be absolutely clear about
And
that.
I also want to note that we changed the merger filing guidelines, we changed the merger rules because of 2 reasons. 1, we elected a president that called on us to do that. And 2, Congress passed laws that instructed the agencies to do exactly this. Further, the Biden-Harris administration did not come in saying that we have done badly for the last 40 years. Because if you say that, that one negates the Google case where we just had a positive
but President
agreement,
Biden, when he-
and the Microsoft decision. Also, I wonder what this panel would do. How are you supposed to use consumer welfare standard for things that do not have consumer prices?
Okay,
right?
that shows
Like
you don't
free
understand the
search.
consumer welfare standard.
Let's be clear.
If-
It says consumer welfare.
Yeah, I think we.
The consumer welfare is determined by prices. If you don't
No,
pay
it's
for
not.
search,
See, you don't, you
I
really
do,
should stop.
I do.
You don't know where you're.
Excuse me.
and that was not written in
I do
statute. That just
actually-
came out of some academics 40 years ago.
We do
This is
want-
not what Congress
We need
intended.
to wrap up this panel, and I do have one more question to
So
ask.
how
But
do you use the consumer
notwithstanding-
welfare standard to address the problems that we
We're not,
see?
that's a.
When companies are big enough to bully entire
This
countries,
is
we
the
need
end,
to do
this
something.
is the end of this panel, not the beginning.
Yeah, I want to point out one thing. There is no consensus that antitrust can solve the problem of the big platforms' dominance. There's none, and most of the expert reports that have been issued come to that conclusion, and therefore suggest establishing a regulatory framework especially designed to go after problems in the digital sector. So what we're saying up here is we don't know what remedies could bring about through antitrust, given the platform economies that these 4 or 5 companies are able to exploit.
Notwithstanding the fact that we're already over time, I want to ask one wrap-up question of Bill, since it's the title of a book that he, I guess, recently edited or wrote. It's What Makes a Great Antitrust Enforcer?
I guess several things that I'd look for in an appointee. Maybe most important, I want broad economic knowledge of the economy. I want a broad understanding of the economy. Second, I'd love to have someone who's had management experience in an institution so that you know all of the practical administrative difficulties you face going in. Third, somebody who has a demonstrated willingness to work in a collegial way and to listen and surround themselves with skills that complement their own, and to listen to them very carefully, to decide, but to listen to them. Fourth, the person who's defined success in terms of how well policy will evolve over the next decade or so, to make the direction of policy better, not to engage in short-term credit claiming. Another attribute that I think is extremely valuable is to have a deep sense of the history of the development of the regulatory scheme, historical awareness, so you can situate what you're doing now. And I suppose last, someone knows a lot about competition law. It's nice. I used to think that was at the top of the list. Now I think it's nice to have because you can pick it up along the way. All of the other things I think are more fundamental to being an effective leader.
Okay. Well, this was a great panel. I appreciate everybody's contribution.
I'd welcome the further conversation, by the way. I think, you raised some fabulous, interesting points, but love to talk about this more.
So join me in thanking the panel.
I think we're supposed to take a break, but it's kind of running behind. So let's just take a very quick 5-minute break and then come back.